The Department of Justice is appealing a judge's ruling that restricts Biden administration officials from talking to social media companies about the content on their platforms. The Tuesday injunction stems from a lawsuit brought by the Republican attorneys general in Missouri and Louisiana, and individuals who claim their posts were taken down. They accuse the administration of abusing its power by contacting social media companies about content related to COVID-19 and elections. In response to the initial ruling, the White House said, quote, "This administration has promoted responsible actions to protect public health, safety, and security when confronted by challenges like a deadly pandemic and foreign attacks on our election." Let's bring in Jamil Jaffer. He is the founder and executive director at the National Security Institute. He also served as counsel to the Assistant Attorney General for National Security at the Justice Department. Jamil, can you help us understand first just what, in practical terms, what exactly the administration can no longer do because of this ruling?
Well, at least for now, what the judges prohibited the administration from doing, and certain officials and certain parts of the administration from doing, is engaging with social media companies, encouraging them to take down posts, to examine certain users, to go after what they believe, the administration believes, or would refer to as misinformation or disinformation online, at least when that information may be protected by the First Amendment.
And do social media companies have their own incentives to combat misinformation? I mean, it seems like there are two ways to stop it. One is to keep the post from taking place at all, and the other is to have community ratings, have community comments, and other things that put a post that might be thoroughly wrong in context with, verified scientific information. Which of those is better, and do social media companies have an interest in either one of those two?
Well, as a general matter, social media companies do have an incentive to engage in content moderation and to protect their platforms from misinformation and disinformation because they want people to keep coming back. And the more their content is infected with misinformation, disinformation, the less likely people are to come back. Now, as far as the types of content moderation you might engage in, whether it's community-based stuff like this, like the measures you referred to, rating and the like, the general consensus is in this country, and has been for 200 years, that the best way to combat a speech that you don't like is not to shut that speech down, but to engage in speech of your own. Taking on that sort of mantle, some of the social media companies, and remember, these are private platforms, so they can do whatever they want on their platforms, have decided that the primary methodology for them of addressing potentially problematic content is to allow the community there to weigh in on it, to provide additional context, to provide links to what they believe might be correct information, and that's a better way than the platform itself taking decisions to take down content. At the same time, clearly problematic content has been taken down historically for many years by these platforms as well. And so there's a little bit of a balancing act these platforms try to engage in dealing with what they see as problematic content.
Getting to that question of the balancing act, when John Stuart Mill was talking about how good ideas could beat out bad ideas, there was always a context, and the pace was different. Is one of the challenges being faced here now that a lie can get halfway around the world before the truth can get its boots on, that the pace of communication and the sheer tonnage of it are what changed that formulation you talked about, which is basically good speech always defeats bad speech?
Well, look, it's not always true, John, as you know, that good speech always wins or always defeats bad speech, but that's always been our understanding. It's better to allow good speech to combat bad speech than to try and shut down what you might perceive as bad speech, for the very reasons that some of the reasons the judge lays out in his opinion, that it can become very problematic, particularly when it's state actors that are doing it. There's nothing, the First Amendment doesn't prevent private actors from doing whatever they want on their own fora. The question is, can the state encourage that? Can the state press that? Can the state coerce platforms to engage in this behavior? And if they are, then are they engaging in state action such that they might be violating the First Amendment? And that's where this challenge comes in, John. You're right. The pace of information being transmitted is dramatically higher today than it was a year ago, than it was 5 years ago, than a decade ago. But the same was true when we invented the printing press, and the same has been true with the invention of the television and the radio and the like. And so the information speed has always kept up, but we've never thought the right approach was for the government to engage in content moderation or to encourage or to push platforms or private fora into content moderation. Imagine if the government were to go to the New York Times or the Wall Street Journal to do that. They would rebel against it. And the platforms, as we can see in this lawsuit, did push back at times, and at times did give in. And so that balance there is what's being litigated now.
Yes, and an important reminder that state actors do not always have benevolent aims behind their actions. Thank you so much, Jamil Jaffer, for being with us. We appreciate it.
Thanks, John.